poor planning or any planning at all is better than no planning. So the person with a will, whether it's just the will only come into force after death, is better than the one without anything at all, because the truth is death is, as I said, the common denominator. One day all of us are gonna die. Hi, welcome back to the Private Wealth Lawyer KE podcast. My name is Diana, or better still, D. Yes, on my socials I'm known as Private Wealth Lawyer KE on Instagram and on Twitter, X now. Yes, and on LinkedIn I'm just Diana Mureithi. It's a pleasure to have you back here. Today we're discussing private wealth management. So in today's session, I'm going to tell you more about what is private wealth management, what are the key considerations, what are the steps to it, and then you get to find out where, depending on where you are in your wealth journey, exactly what is relevant to you and what's of use to you. Why private wealth management? I think because all of us are somewhere on our wealth journeys, right? Yeah, someone is creating their wealth, they just got unemployed and they're just learning how to create their emergency funds and all these other things. Someone else has already actually acquired holdings here and there. They have land, they have properties, they have shares, investment shares. Another person actually has gotten to the place where they've achieved their goal, they're dollar millionaires, or So for all these three types of people, they need a service that allows them to, first of all, curate those goals, then meet those goals, then make sure that they're not derogating from those goals, which is now what we call wealth preservation. So it's one thing that you created the wealth. Now what about preserving this wealth? And then from there, I think the one thing that I like to remind people is that the common denominator among all humans is that eventually all of us are going to die. So you have to plan also in your portfolio for how you transmit that wealth now to your preferred beneficiaries. So private wealth management is basically that. It's a comprehensive service that involves the different stages of your wealth journey in terms of how you're financial planning for how you're acquiring it, legal planning for how you're preserving it, which is wealth structuring, tax advisory, and then also it's also for how you're going to transmit it, which is estate planning. So as private wealth practitioners, there's a part that's done by finance guys, which is the investment managers, whom we work with very closely. There's a part that's done by the lawyers, which is the wealth structuring and the tax. And then there's also a part that's catered to by, say, investment, the guys in investment, which I think I'd already mentioned. So it's a full scope service that covers all those areas of the wealth journey. Family trusts are a tool of wealth management as well as a succession tool. A will is just a succession tool. What does that mean? It means that a will only become operative once the maker of the will dies. So we only consider it after he's died. So it's only useful after death. It's not even useful for during incapacitation, because for purposes of incapacitation, say someone who has a mental health issue, their will not be useful in telling us how to deal with those assets because this person is still alive. In that case, if this person had not, say, created a general power of attorney or a specific power of attorney, you have to go and file for an application for legal managership or guardianship under that at the High Court of Kenya. So the third thing is a prenup is basically a document that states pre the nuptials. A prenup means prenuptial, which is nuptials is the wedding or the marriage. So pre the nuptials, we are agreeing on how our property is going to be held and how in the event that we separate, again, division of that property is going to be done. So also together, another document that may stand in the place of a prenup is called a post-nuptial agreement. This one is, again, just an agreement between spouses deciding how their wealth and their property would be held and how it would be shared in the event of a divorce, and basically how it would always be managed and administered, except that now it's happening after they've already gotten married. So somewhere during the duration of the marriage, people could decide, oh, let's figure this thing out and put it down in writing. That's a post-nuptial agreement. So all of these are, in a sense, wealth management as well as succession tools. A family trust, I think, among all of them is not actually, I think, a family trust among all of them is the most superior because it encompasses different facets. The prenuptial / postnuptial agreement only covers the issue of marriage, property acquired during marriage and how it's administered among the spouses. However, a family trust would also go as far as dictating what rights these beneficiaries of the trust have as against, say, creditors, or in the event of bankruptcy of the patriarch or one of them. So A family trust is more expanded in scope. A prenuptial agreement, a postnuptial agreement is limited in scope, and a will is even further more limited because it's only operative after the death and will only speak to the transmission of the assets. Poor planning or any planning at all is better than no planning. So the person with a will, whether it's just the will only come into force after death, is better than the one without anything at all, because the truth is death is, as I said, the common denominator. One day all of us are gonna die. As lawyers, I think when we advise on now private wealth, our key role, as I've said, is in wealth structuring, the tax planning. So the available tools for wealth structuring are family trusts. We also have because as I said, estate planning is a big part of private wealth management. We have succession tools such as general powers of attorney. We have forms of nomination for certain classes of assets like pension benefits and insurance benefits. Then we have a will, which is basically also it's an estate planning tool. And also holdcos. We have holding companies. Sometimes, depending on how the asset portfolio sits, we will incorporate holding companies as part of the means in which we are holding the wealth. So basically, in determining which tools are best for which asset portfolio, we look to the objectives of the maker, the person, the client, and also their apprehensions. So, for instance, if it's a client who is aged and wants to create a clear plan for how a family business that's a going concern and that's doing very well, say like our local retail supermarkets that's doing very well, wants to create a plan for how it transmits to the children, then at that point we will be considering either a family trust, or if the testator, if the person who's now giving these instructions is willing to split the business into small ownerships, then we may consider a will, because the effect of a will is that everyone is going to get their share. So if there were 5 children and the company has 100 shares, everyone's going to get their 20 shares, and they're getting equally, everyone's going to get 20 shares, 20 shares, 20 shares. But that creates a new complication for the business, because now it means child A could decide to sell their share to, and then the rest of the children have to either buy him out or have to contend with an outsider coming into the company. So if the testator's goal, like it was in the case of Jenga Karume, is intent on ensuring that the wealth remains as a unit, you'll find that many times they'll prefer to have a family trust, because the family trust then will own the business, and then all these children will be beneficiaries of the trust. So the trust deed will have dictated that you're getting maybe a living stipend, or you're getting certain dividends when the company makes money, and then dividends are declared to the trust. Then those dividends are divided in a fixed manner, either equally or maybe whatever other manner, that criteria that the founder has decided on. So the other consideration, other than the objectives, is now the apprehensions. What is it you see in your wealth portfolio that you already know could be problematic? Yeah. So for instance, someone with, say, in a polygamous setup that's already not been working out, then we'll make considerations like that when we're reviewing how to set up that wealth. Or someone who has highly leveraged their wealth, say with banks or other lenders, and therefore has multiple outstanding obligations. So in such a portfolio, we are then looking at it to find out how can we create stop orders. Stop orders means if, say for instance, there's a debenture or a fixed charge over property X, yeah, and the bank could be able to come and enforce over that. How do we protect property Y, which is not under that debenture or under that fixed charge? So in this case, we might create different entities so that we keep this one protected. Or the trust, we might create provisions within the articles of this company disallowing cross guarantees. So yeah, basically it depends on the client's needs, and we always ensure to put into consideration the objectives and the apprehensions that the client has with regards to their wealth structuring needs. A family trust goes further beyond just death, because a family trust is it's a corporate body. What that means is that it's a legal person. So the law recognizes that once you incorporate a trust, it becomes like a legal person, which is a separate entity from me. So Diana Trust and Diana are not the same entity. The law does not view us as the same person. The law views me as a natural person and views the trust as what we call a juristic person, yeah, a legal person. So in so doing, we have created a separation. Once I move my assets into the Diana Trust, It means that if there was a creditor coming for me, Diana, I had signed a personal guarantee with the bank, and the bank is enforcing that personal guarantee and wants to attach assets that are in my name, it cannot touch the assets that are in the name of Diana Trust. It also means that if for whatever reason I am declared bankrupt, the assets that I hold in my name go into bankruptcy and are used to settle the creditors, the assets of the trust cannot be used as such. It also means that in the event that, God forbid, I also am married and then I get divorced, and therefore there's a matrimonial property dispute, that can only be as against Diana, the natural person, not Diana, the trust. So that separation in law is very important because it tells creditors or potential people who are trying to sue you, like where where it stops. It creates a separation between you and the trust. So that's number one. Number two, there's a lot of tax benefits that the trust offer. So you'll find, for instance, a transmission of assets, say from myself to my daughter. If I was trying to give my daughter a home and I transfer to her, I'll be required, because she's my daughter, I'll be exempted from capital gains tax because it's a transfer to an immediate family member. However, on the transfer document itself, I have to pay a tax known as stamp duty, which if the property sits within a municipality, that means it's in Kitusuru or Kileleshwa, I'm going to pay 4%. But if the property sits in Nyeri, in a rural place in Nyeri, I'm going to pay 2%. So if I made the same transfer, but through a trust now, I create a trust for my daughter or my own trust and name my daughter as a beneficiary, then I won't pay both the capital gains tax and I will also not pay the stamp duty. So it's also a tax saving. It's also used for purposes of tax saving. I think another big distinguisher between a family trust and a will is that a family trust is operative during the life of the creator. As I had said before, the will only come into operation once the person who created it has already died. So it doesn't matter what is said in the will, we're not going to consider it if he's incapacitated or if he lacks mental capacity now, or if he's gone into a coma and we need to figure things out, that we can't use the will. But for the trust, it could have spoken to matters of how we deal with basically the assets belong to the trust, including, say, the bank accounts, and therefore we are still able to manage this person's affairs where he's alive, but maybe incapacitated or in a coma or in whichever other issues he may be facing. Yeah. So in a nutshell, family trusts are in many ways a superior way of planning your estate, but also a superior way of managing your holdings when you're alive.